I thought I'd just start my presentation by quickly giving everyone a rundown of what the Environment Defence Office does, just in case people don't have a good understanding of that. So we're a community legal centre, which means that we provide free and reduced rate legal assistance in a variety of means when it's in the public, or when we determine that the matter we're working on is in the public interest. We do this by three main ways. One way we do it is by doing law reform and policy work, which means we try to engage with government agencies about how environmental laws should be improved, how they should be implemented. So we do this by watching and monitoring the government about how they implement environmental laws, and also engaging with government proposals about environmental laws and putting our position forward on how they can be improved, and also doing the same in relation to existing environmental laws. We do community legal education work, which is stuff like today, but it also involves trying to educate communities about the law that applies to the environment, and also how they can then use that law to protect their environment. And we also do litigation and advice work. That work varies from quick 15-minute phone call advice to people who have a concern about a development in their neighbourhood, for example, to more involved legal representation when we decide that the matter has a strong public interest. And the proceedings I'm talking about today, which are the dual gas proceedings, or the HRL, I've called it dual gas because that was the entity involved in the litigation, is an example of the public interest representation and litigation work we do. So just by way of background, dual gas is a fully owned subsidiary of the company HRL, and the litigation was about dual gas's proposal to build a power station in the Latrobe Valley that used brown coal. So in 2010, in order to proceed with this, they needed what's called a works approval, and that's issued by the Environment Protection Authority under the Environment Protection Act. It's the legislation that governs that. And in 2010, dual gas submitted an application for this power station. This slide, I have been involved in a 22-day hearing about this thing, and I still can't explain it that well, but engineering is not my forte. But basically, the diagram on your right is basically a combined cycle gas plant. So that's what a power station that produces electricity using gas looks like. So it's got a turbine, a boiler, and it's in essence a gas plant. On the left, or on my right, on your left, is the process in which dual gas is different to other brown coal power stations and other gas power stations, and it's the process which enables brown coal to be dried out and turned into a gas. So the process basically involves gasifying brown coal and then burning it in a gas turbine. The fact that it's a gas turbine became significant in the case for reasons that will become evident later in my presentation. But just to give you a bit of an outline of the environmental impacts of this particular proposal, the plant also uses natural gas, so depending on how much natural gas it uses, that influences how efficient it is and what its impacts on greenhouse gas emissions and climate change are. But assuming that it uses the minimal amount of natural gas necessary to fire it, the dual gas proposal is roughly maybe 20% more efficient than the existing brown coal fire power stations in the Latrobe Valley, so that's comparing it with things like Loyang and Hazelwood. But it is also less efficient than the newer black coal power stations that are being built or upgraded in other parts of the country. And still, even the actual proposal used about 20% natural gas, I think, from memory, and running at that, using that level of natural gas, the proposal was still going to emit per annum, and it's a relatively small power station as well, 3.2 million tonnes of carbon dioxide a year into the atmosphere. So that's a bit of a rundown of the environmental impacts. So in 2010, dual gas submitted a proposal for a 600 megawatt power station to the EPA. With 2 gas turbines, so there was 300 each. The EPA said that you can't have 2 gas turbines, you can only have 1. The main reason that they gave for this was that initially dual gas proposed that 1 gas turbine would operate on natural gas while they figured out how well the gasified coal would work. And the EPA said that you're not using the most up-to-date and modern gas turbine for natural gas. So you can't have the natural gas turbine, even though that's environmentally better than the coal turbine, but they can't use the most up-to-date gas turbine using the coal gas that only works on natural gas. So that's it's quite a complicated reasoning, but that's why the EPA came to their decision. And following that decision, a series of environmentalists and environment groups, and also Dual Gas itself, took the EPA to VCAT, appealing the decision. The environment groups have a right under the Environment Protection Act. It's a fairly constrained, fairly complicated right, but they do have a right to challenge works approvals in VCAT. It's a merits approval, which means that they're asking VCAT to stand in the shoes of the EPA and make the decision again. The groups that appealed to VCAT were the Doctors for the Environment, so they brought the proceedings on a number of bases. Basically, they were concerned about climate change impacts, but they were also concerned about other impacts from emissions from coal, and these include particulate matter, sulfur dioxide and nitrous oxides, which all have quite significant health impacts, including encouraging or bringing on childhood asthma and those sorts of things. Should be noted that I think the Latrobe Valley, and this was recognised by the EPA in the case as well, the Latrobe Valley is already at its kind of upper limit that it should be for sulfur dioxide emissions, so that's already a health impact concern on the Latrobe Valley community. Martin Shields also was an individual who brought proceedings, and he was basically concerned about climate change impacts, particularly because of the way the legislation's framed, climate change impacts on him and his family in the context of, just the global climate change impacts, so rising sea levels, all those sorts of things that we should all be fairly familiar with. And then the Environment Defenders Office acted for two groups. We acted for Environment Victoria, which is basically Victoria's peak environmental group, and also a local group from South Melbourne called Locals into Victoria's Environment. And I'll go through our grounds in more detail later, but basically we were primarily concerned with the contribution that this proposal would make to greenhouse gas emissions and climate change. The Environment Protection Act makes it difficult for third parties. So we do have a right to go to VCAT, but it's a fairly constrained right. You have to show that your interests are affected, so that means that you have to show that not that you just care about it, but that you so fundamentally care about it that you're, in the context of a group, that your fundamental reasons for being as a group are affected by the decision. But then you also, there's two other, then as well as limiting who can bring proceedings, it also limits the basis on which you can challenge a proposal. So you can either challenge it on the basis that your interests will be adversely or unreasonably affected, which is an extremely difficult test to meet, or you can challenge it on the basis that it won't comply with the state environment protection policy, which is the main policy that governs what proposals can go ahead if they're going to have an impact on air quality. So it was the main sort of regulatory instrument that we were arguing about in the case. Martin Shields brought proceedings on the basis that his interests as an individual would be adversely and unreasonably affected by the proposal. He was arguing that he invests in a wind farm, and also that just generally climate change impacts are going to have serious environmental and economic impacts that will affect him as an individual and his child as an individual eventually. And then I think I've explained the basis that the other parties brought the proceedings, but they were all seeking to argue that it wouldn't comply with the regulatory instrument, the SEP. The only party so far to get standing, so the only party that actually has a case that will be decided on at the moment definitely is Environment Victoria. So early on in the piece, VCAT decided they have standing. It's been a 22-day hearing, everybody's put in their submissions, and Martin Shields, Doctors for the Environment, and Locals into Victoria's Environment still don't know if they're going to be, if their concerns are going to be taken into account, because they don't yet know if they've got standing. So that's a fairly concerning aspect of Victoria's environmental law from my point of view. So I'll just try and quickly take you through the grounds that were argued by Environment Victoria and LIV. So as I said, we had to argue that we could only argue about it on the basis that it wasn't consistent with the SEP, and we said that it was inconsistent with the SEP in three main ways. First of all, the SEP has a series of policy principles, and these by and large include the principles of ecological sustainable development, so they include things like intergenerational equity, the precautionary principle, and the integration of economic, social and environmental factors into decision making. The SEP also requires that decision makers act in a way that's consistent with state and national measures designed to address air quality. And in this context, we were arguing that the Victorian Climate Change Act was a state measure that had to be taken into account by VCAT. The Climate Change Act was passed in 2010, and I'll go into a bit more detail about some of its provisions in a second. And also, we argued that it wasn't best practice. The SEP requires that anything that's going to emit significant amounts of greenhouse gases has to be best practice in its industry sector or its activity. And again, I'll go into that more detail. And that best practice issue, I think, is, I mean, obviously, I should tell you all that there's no decision yet. The hearing ended in mid-February and the judgment's reserved. So, but based on the arguments, I think that best practice issue will be the crucial issue in determining who's successful in the case. So, back to the policy principles. The 3 policy principles that we said were not complied with was intergenerational equity. So we're saying the significant amounts of greenhouse gases that are going to be emitted by this proposal is inconsistent with intergenerational equity because it's using our resources today in a way that's going to prejudice the ability of future generations to live happily and healthily on the planet. And tied into that argument, we also actually, I'll save that for another principle, don't worry about that, so I'll leave that there. We also said that it was inconsistent with the precautionary principle. In the way that that's worded in the SEP, it says that you've got to avoid irreversible damage to the environment where possible, and you've got to do a risk-weighted assessment of the consequences. So we were saying significant contributions of greenhouse gases contributes to climate change, it's going to do serious and irreversible damage to the environment. We brought evidence from a climate scientist who said that the proposal would contribute to climate change by a small but significant amount, and that evidence was unchallenged.